Hello. Hello. Check. Hello. 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 Hello.
જો હેડફોન લગાવો તમારા બે અહીંયા રહેવા સ્ટાર્ટ થશે કંઈ તો વારા ઘડે કહેવાનું
Hello. Hello. Check. Hello. Hello. Okay.
You may then invite the first speaker for the applicant to commence their ordinance.
Agent seeks permission to approach the dais. Much obliged. Greetings to the honorable bench. Agent seeks permission to collectively refer to the bench as your excellencies. Much obliged. Am I audible now? Agent seeks permission to collectively refer to the bench as your excellencies. Much obliged. My name is Ankita and I, along with my co-agent Charvi, are going to represent the Republic of Ramasa in the case of the Republic of Ramasa versus the Matai Kingdom of Allora. With the permission of the honorable bench, at the outset I would like to clarify that I'll be dealing with issue 1 and 2 for the next 17 minutes, post which my co-agent will be dealing with issue 3 and 4 for another 17 minutes. With the permission of the honorable bench, we'd like to reserve 2 minutes for rebuttals. Much obliged. If your excellencies are well versed with the facts, may I please proceed with my submissions? Much obliged. My first submission before this honorable bench is that Allora is responsible for the violation of international law by transferring crypto funds to Nizavi Most Mati, by failing to trace anonymous transfers, and by not seeking mutual legal assistance from Ramasa. The first limb of my argument is that Allora has violated state responsibility to curb terrorism and seek mutual legal assistance from Ramasa. Firstly, both Allora and Ramasa were a part of MOU which was signed between them in the year 2022. Please refer to para number 11 of the Moot proposition that was provided to us, wherein this particular MOU obligates both the state to cooperate in preventing money laundering and terror financing by cooperation. It shall be noted that Allora failed to discharge the same. Secondly, Allora is a member of United Nations, which means that Allora is obligated to adhere to UNSC resolutions, which is 1373. Herein, a very pertinent point to note is how these UNSC resolutions are interpreted. Before getting into it, a member state is bound by UNSC resolution under Article 25 of UN Charter. Now, deliberating on the point as to how these particular UNSC resolutions are interpreted, it was in the case, ICJ case of Nambia advisory opinion, legal consequences for states of continued presence of South Africa in Nambia. Herein, 5 principles were laid down as to how UNSC resolutions shall be interpreted. With the permission of the Honorable Excellencies, I would like to reiterate those 5 principles. Firstly, ordinary meaning of the terms. Secondly, purpose and context. Thirdly, consistency with UN charters. Fourthly, intention of UNSC. And lastly, practical effectiveness. It shall be noted that whether these UNSC resolutions resolutions obligation will be based on a conduct or a result shall be determined based on the wordings and intent of that particular UNSC resolution. Coming back to my point, the UNSC resolution 1373 mandated the state to criminalize terror financing, freeze financial assets, and ensure that their territories are not under use of terrorist activities. Herein, Alora blatantly failed to adhere to this particular UNSC resolution, as it mandated them to make sure that no terrorist activity is taking place in their territory. If Your Excellencies don't have any questions from this issue, may I proceed with my... I don't have the bare text with me. Oh. Right. Apologies. Right. Your Excellencies, the UNSC already has designated Nizami Mati as a designated terrorist organization under UNSC Resolution 2764. Right. Your Excellencies, for that, under UNSC Resolution 1373, it was a mandate of the state to criminalize terror financing, to freeze financial assets, and to ensure that their territories are not being used for terrorist activities. And hence, all the actions of Ramasa are under the purview of UNSC Resolution 1373.
Did the Security Council resolution permit a state to execute the resolution in case of violations? In other words, can the Security Council resolution, if violated, be executed by any member state, or it has to be done so by the Security Council itself?
It has to be done by the UN Security Council as well as the member states.
Under which provision of the Charter does a member state have the right to execute a decision of the Security Council if violated?
Your Excellencies, I can't remember it right now. Apologies for the same. Your Excellencies, with your permission, may I please move to my next submission? My next submission before this honorable bench is that the second limb of my argument is that Alora has violated international law by failing to trace anonymous transfers. In this slide, firstly, I would like to emphasize on the point that the principle of due diligence is of great importance in this particular case. In the pulp mills case of 2010, it was stated by the ICJ in paragraph 101 that the court that the principle of prevention as a customary rule has its origin in due diligence that is required of a state in its territory. It is every state's obligation not to allow knowingly in its territory to be used for acts contrary to the rights of other states. Herein, it is very pertinent to note, Your Excellencies, that Alora has been in blatant violation of this particular due diligence obligation, which I'll be establishing through the facts. Firstly, Your Excellencies, the facets of money transfers have been increasing ever since. One such facet of money transfer is cryptocurrency transfer. It shall be noted that the Alora anti-money laundering law, which is in place, fails to address this particular facet of money transfer through cryptocurrency financing, as has been repeatedly stated in our fact sheet that Alora actually failed to regulate cryptocurrency transfers and actually failed to monitor the same. It shall also be noted that in the pulp mills case under para 197, it was held that an obligation which entails not only the adoption of appropriate rules and measures, but also certain level of vigilance in their enforcement and exercise of administrative control, which means that merely making a law does not dispense Alora with stating that they have made the law and they have followed due diligence. However, to establish that they have followed due diligence, there shall be specific vigilance regarding the same. And our submission to this slide is that Alora failed to mandate the cryptocurrency transfers. My second submission here would be that the authorities of Alora failed to mandate crowdfunding websites, which is given under para 12 of the Moot proposition, that the supporters of Nizami Mati were under false pretenses trying to transfer cryptocurrency funds, and Alora was unaware of the same, and actually Alora failed to regulate the same. and Nizavi Most Mati supporters could draw a lot of funds from there as well. My third point here would be that an unnamed, unflagged ship passed the territory of Alora without being noticed. It is a very important point in this particular case, because under Article 110 of UNCLOS, it is a state's obligation to check suspicious unflagged vessels that pass their ports. It shall also be noted that Alora's maritime sector was the biggest grossing of their economy, which is mentioned in para 4 of the Moot proposition. Despite all these circumstances, an unnamed, unflagged vessel passing through their territory, surpassing all the otherwise required surveillances, poses a serious doubt on the actions and intent of Alora.
Madam, do you think that any party is missing in the proceedings? Article 6, somewhere some state was not a party to the proceedings. That's
Your Excellencies,
one of the state is not a party to the proceedings. That the defense is taken.
Your Excellencies, we both the Republic of Alora and
I can give you a clue. Casa de la Valor, a state which is not a party to the proceedings. What do you have to say?
Your Excellencies, the attack which happened, the unfortunate attack that happened in Casa de Labrol, and the proceedings regarding the same were started in Ramasa firstly, and then Ramasa imposed certain sanctions on Alora, based on which both the parties had decided under a special agreement to come before this court. Your Excellencies, emphasizing on my point again, that an unnamed, unflagged vessel passing through Alora poses a serious doubt on the intent and actions of Alora herein. My next submission is that please refer to para 7 of the Moot proposition and para 16 of the Moot proposition, wherein Nizavi Most Mati has been time and again declaring that our motto is to establish and expand. And secondly, Nizavi Most Mati before the attack explicitly declared that we are coming for you. Despite these particular things, Alora again failed to regulate the same. Alora again failed to regulate their security ports. Alora again failed to do anything about it, be it even declaring Nizavi Most Mati as a designated terrorist under their territory. Your Excellencies, my next submission in this slide would be that the two IT professionals, which are mentioned under para 15 of the Moot proposition, the two IT professionals who were previously employed with the Defense Ministry were caught by Ramasan authorities, and they admitted to the fact that they were trying to transfer cryptocurrency funds. It shall further be noted that these particular IT professionals also testified and showed evidences of emails to us which were sent by the Aloran Defense Ministry themselves to them, stating them to be discreet and stealthy while transferring these cryptocurrency funds. This particular fact establishes
Aurora Defense Ministry successfully shut down a crowdfunding campaign. How do you deal with that?
Right. Your Excellencies, it shall be noted that under para 12 of the Moot proposition, it is given that there were various crowdfunding websites that were operating under false pretenses, which were operated by the supporters of Nizavi Most Mati. Under the clarifications, it is one crowdfunding website that has been mentioned. Your Excellencies, by my submission, I wanted to emphasize on this particular point that the Aloran Defense Minister himself was involved in this particular transaction, as the email was sent through an official email of the Defense Ministry to the IT professionals who were employed under them, which shows that the government themselves had the knowledge of these particular transactions and particular act as well being taken place. My next submission before this honorable court.
Counsel, you are trying to build the argument relating to state responsibility. So could you cite some international law on state responsibility, or just we take it what you said?
Right. Your Excellencies, my submission to that would be, right now I am dealing with the point of due diligence, wherein I am establishing the instances wherein it can be inferred that due diligence was not properly followed in this particular case. However, for your Excellency's reference, I would like to cite the case of Nicaragua versus USA, wherein the effective control test was established, which is...
You can't give it
That's
the
why I told you in the beginning all what is very good in the court of law, sir, I submit it later on. This is like a cricket match. You can't tell कि sir आज बैट भूल गया हूँ कल बैटिंग.
You have to at least give citation if you have no Xerox copy, but you have to give the citation. From which book you have read it?
Your Excellencies, right now I don't have the citation with me. I only have the year and the case name with me. Apologies
So
for the same.
next time when you go for your book courts, this is what we are just hinting at it, that you should be ready with your case law.
Right.
See, if you appear in the Supreme Court, they only acknowledge Supreme Court cases. They too also know which court, which citation is due. If you go with the AIR, Supreme Court will not accept it.
Right. Your Excellencies, it is a ICJ judgment that I'm citing.
ICJ report,
Oh,
year,
ICJ,
case
right.
number.
ICJ is fine. Both these cases are there by the International Court of Justice. Based on environmental jurisprudence, fine. But my brother is asking anything before pulp. Before pulp mills, there were umpteen number of judgments
Right.
on state responsibility. Beginning from Prince Filter.
Yes.
Beginning from that whole days.
Right. Your Excellencies,
Go ahead.
Go ahead.
Don't get
Yeah.
tangled into all this. Go ahead.
Your Excellencies, I just quickly finish my arguments.
Unfortunately for you, you have a double doctor. He is academically also sound. Yes.
Your Excellencies, I'll just quickly finish my arguments on due diligence and then move to the state responsibility
Yes.
part. So, my last submission in the light of due diligence was not followed would be that please refer to para 27 of the Moot proposition. Herein, the Aloran Defense Minister, Ms. Venta Riod, was heard in a meeting with Nizavi Most Marti officials offering support to proxies operating abroad. This transcript by the Pilar Junto's media reports have revealed that Ms. Riod possessed the data from VASPs, which again poses a light on the fact that Ms. Riod, who was the defense minister, was aware of the fact that these particular funds were transferred.
Just one question for you. Sorry to interrupt. Is there any case law from the ICJ which talks about the use of media reports by the International Court as evidentiary, having any evidentiary value in such proceedings?
Right. Your Excellencies can please refer to the case of Democratic Republic of Congo versus Uganda, which is a 2005 judgment wherein media reports were considered to be corroborative. Further, the Bosnia genocide case as well, media reports were considered to be corroborative.
What do you have to say last three lines of paragraph 27? Three military official who shared nautical chart of the Nibra and Kalangoshi with the...
Right. Your Excellencies, again, the fact that Alora let a ship pass through their port without any surveillance, adding that fact along with this fact that Aloran military officials were sharing nautical charts with the Nizavi Most Marti, again makes the case very easy for the side of Ramasa by establishing that there was an unbroken chain of circumstances which led to the attack at Casa del Ebro.
Then why you are not showing that? Anyway, yeah.
I was just coming to that, Your Excellencies.
Your
So,
time was running out.
my apologies, Your Excellencies.
Yes.
So, the agent finally submits that Alora not just failed to monitor anonymous transfers, but also failed to regulate the virtual asset service providers, and moreover, it was not just limited to this. The Alora also failed to enforce its own money laundering laws with the permission.
That is exactly what I wanted to ask you. Do you stop your watch when we are interacting or? No, you don't do that. I'll exercise my jurisdiction for all citizens. 2 minutes more to you because
We have interacted more with you.
we have interacted with you, so the time is given to you. It will be given to team 2 also.
Much
It will be
obliged.
given to the other candidates.
Much obliged, Your Excellencies. My next submission in this light is that Alora is responsible for the militant attack at Casa del Ebro and is obligated to pay reparations for the death of 5 Ramasans because firstly, the The acts of Nizavi Most Mati can be attributed to Alora because it exercised effective control over the same. For the reference of your excellencies, I would like to cite the case of Nicaragua versus United States, which is cited on page 11 of our Moot, of our written submissions, wherein the effective control test was confirmed and which required a state to have significant involvement
Only
in
thing that
planning.
is not given to you because we have given only 2 copies and we are 7. None of us has that your
Lordship should have it.
no, that's not
Your,
that.
your excellencies, we were not asked to provide the same
Anyway,
to
at least
the
1 copy if it is given to us at least.
Do you have your testimonials? उसका testimonials है आपके पास? इसमें box लगे होंगे पहले.
That submission.
that was the
Memorial
organizers
to
part.
Memorial तो होगा आपका.
Your excellencies, that was the organizers.
नहीं, we are not asking you. We
Okay.
are asking this.
Asking the
Brief नहीं है. कोई बात. Anyway, we will proceed.
No, so just for the,
Sharma,
is Mr. Sakshat
memorials
here?
के marks हैं
नहीं.
तो नहीं हमें नहीं देना है तो तू मेमोरियल थोड़े दे दी 2 कॉपी हो तो भी नो इश्यू.
Right. Further, your excellencies,
Do you have any extra copy of your memorial? So just pass it on to the chairman.
We are only supposed to bring them.
आप जब आए थे आपका भी था
And the memorials are, the idea is to us not be infringement.
memorials are not given to us because they are already adjudicated by.
Yes, exactly. And the whole idea is that
Anyway, so then leave it. If it is, but then we go by. Yes,
Yes.
sorry, yeah.
further, your excellencies, under Article 8 of RCEVA, it establishes that the actions of a non-state actor can be attributed to a state if the state exercises effective control over them. It is submitted before this honorable court that the Aloran officials provided direct funding to Nizavi Most Mati through cryptocurrency transfers, and these transfers demonstrate clear involvement of these Aloran authorities in the alleged act. Furthermore, Aloran officials also provided nautical chart to Nizavi Most Mati, which facilitated the act. In this light, I would like to emphasize on Article 4 of RCEVA, which states that the conduct of a state organ will be considered as a conduct of state. Herein, the state organ is interpreted as an entity which is legislative, executive or judiciary in that government. Herein, the Aloran Defense Ministry was executive of that particular state. Further, Article 7 of RCEVA of draft articles establishes that the conduct of any state organ, even if it exceeds its authority, can be attributed to the state. Herein, the defense minister, council seeks permission of extension of 2 minutes.
Just complete this argument, please.
Herein, the Aloran defense ministers, although they were exceeding their authorities by helping Nizavi Most Mati, however, it is emphasized again by the agent that these particular defense ministers were involved in that particular act, and hence their liability can be attributed to Alora. And based on the evidences that I presented before this honorable court, an unbroken chain of circumstances is formed, which concludes to the point that the liability of Nizavi Most Mati can be attributed to Alora, and hence Alora is responsible for the militant attack at Casa de Labrol.
Thank you. I just have a question. We don't want you to answer this question now, but perhaps in the rebuttal, I want you to take your time to ponder over this. You refer to Article 8 of the RCEVA, which has 3 possible elements to establish attribution. One is that the group or persons concerned is in fact acting on the instructions of or under the direction or control of that state in carrying out the activity. We'd like you to establish which of these 3, either individually or cumulatively, apply on the facts that you have outlined. Thank you.
Shall I answer it now?
No. In rebuttal.
Take your time.
Right. It was an honor arguing before this bench.
Thank you.
Agent seeks permission to address issue 3 and 4 of the present case.
So the issue 3 deals that RIMASA did not violate international law through its legislative or judicial measures of constraint and hence is not liable to pay any reparations. In order to submit, agent has 3 submissions to make. Firstly, that the Immunity of State Act, which is the legislative measure in hand, is in conformity with international law. Secondly, that the judicial measures of constraint are not violating the sovereign immunity of ALORA. And thirdly, that we are not liable to pay any reparations. Moving to the first limb of my first submission, that state immunity forms a part of customary international law, but there are established grounds to deny it. In order to substantiate my claim, the agent would first go to the UNSC resolutions, which are mandated to the members in light of Article 25 of the UN Charter. This particular UNSC resolution 1373 states that all states shall prevent and suppress financing of terrorism, and to ensure that these acts are brought to justice, states need to have a domestic legislation for the same. Moving on, the second limb is FATF guidelines on criminalizing terrorist financing. All countries have to criminalize terror financing according to the Terrorist Financing Conventions and the UNSC resolutions. Thirdly is the United Nations Convention on Jurisdictional Immunities of State and Property. We would like to state that both ALORA and RIMASA are parties to this convention, and under Article 12 of this convention it is stated that state cannot invoke immunity from jurisdiction in a proceeding wherein injury to a person or damage to a property, tangible or intangible, is concerned and the act or omission is attributable to that particular state. So we are trying to submit here that the particular attack that took place at Casa de la Brol, which led to death or injury to people, falls under this particular exception.
Article 12 of what?
United Nations Convention on Jurisdictional Immunities of States and their Property.
And is that enforced yet?
Your Excellencies, that is not in force. However, both ALORA and RIMASA are parties to this convention.
Okay.
My next submission, which is the dissenting opinion of Judge Trindade in case of jurisdictional immunities of state, Germany versus Italy. Para 299.
You are committing the same blunder. You should have got the hint from my brother when he pointed out to your colleague. You should have searched your Google.
I am extremely sorry, Your Excellencies.
वो कोई फर्क नहीं पड़ता है. Marks आपके कट हो.
नहीं कौशल, they may not have mobile. Yes.
I'm extremely sorry, Your Excellencies. I will incorporate that next time. Under para 299, it is stated that state immunity cannot stand in the way of realization of justice. The pursuit of justice is to preserve the ultimate goal of providing to encompass the grievances of the victim, and it is established that just cogence norm stand above the prerogative and privilege of state immunity. What we are trying to argue and submit here is that the dissenting opinion may not be binding on this bench, but it does hold a substantive value. By that,
Counsel, I have just a small query. You mentioned that dissenting opinion is not binding. What about the bindingness of the main judgment itself?
the judgments of ICJ also are not binding on this.
What value do they hold for us?
Persuasive value.
Thank you.
Right. My submission here is that under Article 57 of the UN Charter, it is stated that if a judgment does not represent in whole or in part the opinion of the majority, then they are allowed to give a dissenting opinion. And this underscores the idea of institutional recognition of dissenting opinions. Other than that, former ICJ President, Sir Rosalind Higgins, stated that dissenting opinions reflect the diversity of legal reasoning and often pave way for future legal developments. It is in this slide that I am requesting the court to consider this dissenting opinion. Now, our next submission in this very light of just cogence norm, we are trying to argue here that in the case of Iranian assets, that was in 2019, no clear definition of terrorism is present. There is no one universal applicable definition of terrorism. In this slide, we can also see that when there were 9/11 attacks, in that light, there was the UNSC resolution 1373 that was brought into picture. This has been argued by many scholars and many states that in order to, we can see that terrorism holds a great value today because of its the serious consequences that it can have on the international peace and security. And scholars have argued that hence, even though terrorism cannot be is presently not an established just cogence norm combating terrorism, but it can achieve the status of a quasi-just cogence norm. Because there's
What do
a,
you mean by just
they are norms that from which no derivation is possible.
Which article of Vienna Convention on Law of Treaties refers to?
Your Excellencies, I know that I'm.
If you're not aware, you can move on to your next argument.
Okay, can I bring forth a point that if my argument here is that this is an upcoming just cogence norm, and under the Vienna Convention on Law of Treaties, Article 64, it is stated that if there is an upcoming just cogence norm and it is in violation of a particular treaty that is in place, then this upcoming just cogence norm can prevail. So our submission here is that terrorism be considered as a quasi-just cogence norm in order to prevail over the concept of state immunity.
Now coming to the facts, have you read when anybody is settled to dispute between two countries? Attempt was made.
Sorry, can you please repeat?
Is there any attempt is made to settle the dispute between two countries?
Right. So just after the attack that took place, there was a High Court proceeding in High Court of Tremlon.
Settlement attempt in London. I am giving you the clue. Para 35, I can give you the further clue.
Right. If I can. So this is after the sanctions regime came into picture.
Therefore, I have said settlement.
So-
Read paragraph 35.
Right,
You should
so-
be master of the facts at least.
Right, Excellency. Basically, this particular dispute, the discussion that went on for 3 weeks, this is after the sanctions regime came into the picture. This is on, as I'm aware, this is on 12th February, and the sanctions regime came in picture after 17th January.
Yes.
Right. May I move to my next submission, please?
Yes.
Okay. My next submission here is that the judicial measures of constraint are not violating the sovereign immunity of ALORA. In this light, as we have already attributed the act to ALORA that they were involved in financing of terrorism, and in that light, under the UNSC resolution 1373, it states that any party which is involved in financing of terrorism or terrorist activities, their assets can be freezed, and other financial assets of them can also be freezed in order to bring complete justice. So this particular judicial measures of constraint are in parlance to this UNSC resolution is our submission here. My next submission here is that RIMASA is under no obligation to pay reparations to the state of ALORA. Here we are trying to argue that all the measures of constraint that have been taken are lawful in nature, and hence, because they are lawful countermeasures, we are not liable to pay any reparations for the same. If your Excellencies are with me, can I move ahead with the fourth issue, which talks about the sanctions regime?
Yes.
For proving that RIMASA's sanctions regime is in conformity with international law, the agent has 6 submissions to make. My first submission is that the due procedure required before undertaking such countermeasure has been fulfilled. Herein, Article 52 of RCWA states 2 particular conditions. First, that before taking countermeasures, the injured state shall call upon the responsible state to fulfill its obligation of secession. And secondly, before taking these countermeasures, you have to notify the responsible state and offer to negotiate. We are trying to contend here that both these conditions have been fulfilled. In order to substantiate the first condition regarding prior notice or intimation to be provided, it is to be noted that no specific form or procedure is required to be followed to put the responsible state on notice. And even a general condemnation of their internationally wrongful act is enough in this present case. I request your Excellencies to please refer to para 26 of the Moot proposition.
1 second. Just you are referring to the wrongful acts.
Right.
So, is there any clear definition on the wrongful acts internationally?
Your Excellency, I'm not aware. Can I come back to that later?
Continue.
I'm sorry.
Para 26.
Para 26 of the fact sheet.
Yes.
It is stated that by the Foreign Minister of RIMASA that the brutal attack on Casa del Laboral Stadium is a well-orchestrated act of terrorism conducted by the Marty Kingdom of ALORA, and such acts are not immune under international law, nor is there anything under the customary international law recognizing it. This is the first instance of general condemnation of the internationally wrongful act. Second is para 22 of the fact sheet. Para 22, if your excellencies are with me, it is stated by the Ramasan government that if they will not take action, then we will. And this time we will not wait for the UNSC. There are two instances clearly before taking the sanctions regime where there has been a general condemnation of the wrongful act. Hence, the first condition stands fulfilled. The second condition is...
Are you saying that general condemnation without specifically writing to the other side amounts to a notice?
Yes, Your Excellency. It does
Are you
not...
aware of ICJ judgments to the contrary?
This particular reference has been taken from the UNSC, UNGA resolution.
All right.
Okay.
UNS resolutions are binding?
No, they are not binding.
All UNGA resolutions are binding or non-binding?
They are not binding, except we are parties to two. So that may be binding on us, but other than that, UNGA resolutions are not binding.
Yes.
Okay. The next if I may move to the next condition. The next condition is the requirement for offering to negotiate can be dispensed with. In this light, we are trying to argue that if the opportunity to negotiate is not lost, then it can also be undertaken after the sanctions regime is brought into picture. In this case, we can refer to para 35 of the fact sheet, wherein after the sanctions regime, a 3-week discussion and negotiation went on between both the countries, which shows that the opportunity to negotiate was not lost. Hence, the second condition stands fulfilled in this light. Moving on to the next submission, that the sanctions undertaken are proportional in nature. So, Article 51 of the RCWA states that the countermeasures that are taken have to be proportional in nature, which means that there has to be no unnecessary, only the necessary infliction of harm has to be done as is necessary, and no unnecessary harm is to be imposed on the other country. Herein, the para 30 of the Moot proposition is the sanctions regime, wherein it is given. If your excellencies are with me, under section 3, they talk about freezing of assets and bank accounts of people who are officials associated with crypto financing and are contributed to terror financing. It is to be noted that nowhere does the sanctions regime mention that it is to affect any individual of Allora who is not involved in terror financing. This is also in light with the UNSC resolution 1373, as has been stated, wherein you can freeze funds if a particular party or individuals are involved in terror financing. The second restriction that has been imposed under section 5 of the sanctions regime, which is the requirement, the travel restrictions imposed, and it is to be noted that the travel restrictions imposed are not absolute in nature. There is just a specific requirement of special visa. That is also limited to the individuals that have established links with Nasavi Most Marty, and it is in no way to impact any Alloran individual who is not involved in any way to the terrorist organization. This is also in parlance to the Chicago Convention that airspace can be restricted in cases of public order, safety, etc.
Can you give us the full title of the Chicago Convention and the year in which it was concluded?
Your Excellencies, at the outset, we are not parties to the Chicago Convention. It was...
You mentioned Chicago Convention as part of your arguments.
Your Excellency, currently I don't have it with me. I will get
Proceed
back.
further.
The next...
Then counsel, second thing, when you refer anything, you must have a history, complete history.
Yes.
When it was born and when it is come into effect. Any question can come. Yes.
I'm extremely sorry, Your Excellency. The next restriction that has been imposed is a trade embargo that has been imposed on materials like gold, silver, copper, and any other material that may be involved in the military-industrial complex of Allora. I would like to also state that gold, silver herein or copper is involved because these are the metals that are commonly alloyed with other metals in order to attain certain properties like hardness, melting point. This in a way helps to create a more advanced weapon. And these metals are those that are only linked with the military-industrial complex. And
are you sure that these are the metals linked only with the military-industrial complex? Are there no other use for gold and silver other than the military-industrial complex?
So the trade embargo that has been imposed on these metals only to the limit they're being used by the military-industrial complex.
But how would you ensure that? Because what's the practical way in which you can make sure, as a sanctioning country, that the other side, that your sanctions are limited only to the use of gold and silver in military-industrial complex and not, say, let's say for jewelry or for other purposes?
We have been, the countries of Rimasa and Allora have been trading together for a long time. We have had a long maritime
trading partnership. In this case, we know that their military-industrial complex is also dependent on these materials that they take from our country. So we, as a matter of practice, are aware that this is the particular amount usually taken by the military-industrial complex from our end.
As a clue, it can be said that these are expensive minerals which can be used for money laundering, because the nature of their composition is such. They are expensive material. They can be used for funding of terrorist activity.
Absolutely, Your Excellency. Can I bring another fact to Your Excellency's vision? Is that paragraph 1 of the fact sheet states that, yes, so it states that Rimasa as a country has a lot of, its mining sector is centered around the production of gold, silver, copper. So imposing a trade embargo is also not, it's also going to impact our industry in some way. But it is only done in good faith, in a proportional way, to not to curb terror financing, and not in any other way to hinder any other industry that is not involved in terror financing.
One question to you on that point, and do you think that such sanctions, it's a blanket sanction on an entire sector, right? Do you think that has adverse human rights consequences on the livelihoods of people who work in that sector? Is that a relevant context for deciding proportionality?
Your Excellency, we would like to submit that these sanctions are only targeted towards the military-industrial complex or the industries involved in terror financing. We are not trying to impose any blanket ban on any industry not involved with Nizavi Mosmati. Okay, I'm sorry, yes.
No, I mean, I would like you to specifically answer the question whether you think that this has any adverse human rights consequences on livelihoods of people, and then contextualize your answer within the within Article 50 of the RCBA, which says countermeasures shall not affect obligations for the protection of fundamental human rights, right? So that's one of the tests for us to determine as a court whether your countermeasures satisfy the requirements or not.
Absolutely. Your Excellency, can I take 5 seconds to just... Your Excellencies, in the case of in the Lockerbie case and certain Indian assets case of 2019, it has been stated that sanctions are justified to an extent wherein they may cause human rights violation, but there are certain conditions attached to it. It has to be for a legitimate purpose. Secondly, it has to be proportional in nature. These sanctions have to be targeted. And fourthly, they should not exceed necessity. We are trying to submit here that there are any human rights violation that may have occurred as a consequence of our sanctions are only resulting as a breach that was on their part. As a response to that, the countermeasures that have been taken are all following these particular considerations of proportionality, necessity, legitimate purpose, and there is no use of force. That is...
all the arguments you have made, Ms. Counsel, thus far on the presumption that you are an injured state. But the people who were actually killed, only 5 or 7 were from your country. The rest, on behalf of whom you are imposing these countermeasures, are not your citizens, right? So in that context, you are actually a non-injured state. Do you have the right as a non-injured state to take countermeasures on behalf of people who are not your citizens and who are killed in a third state?
Yes, Your Excellency. Even a non-injured state can invoke, take countermeasures against this other state. It is provided in RCBA. I may not be able to get to the exact section, but even in collective interest of people, collective good, even a state which is not non-injured state can take countermeasures against the other state. I'm extremely sorry for the exact section. I will ensure that. Okay. Can I? The fact sheet is silent on...
That is where your innovative ideas of Mooter comes. Anything?
Can you please repeat whether
Whether is my brother idea. You are taking a cause for all those who are killed, right? Most of them were not your citizens. Most of them belong to the country known as Casa de la Flor, where this incident happened. So as the fact sheet is concerned, it shows that the military vessel was also at the SAP. And there were people who were killed. So as Casa de Beron, started any legal action against this country where these terrorists were originating from?
Your Excellencies, as of now, Casa de Labrol has not started any legal proceeding.
Okay.
However, when we have approached ICJ, it's also for the collective interest of people, and that is my
That was
submission.
innovative. Good.
Can I move to my next submission? Thank you, Your Excellencies. All right. The next, can I move ahead with my next submission, which is based on the WTO obligations that exist? So the next submission is we are in conformity with the WTO obligations. Firstly, because we fall under the exception of security reasons, and under this Article 21 states that nothing in the agreement prevents any contracting party from taking any action which is necessary for the protection of its essential security relating to goods and materials. Herein we fall under this particular exception, and hence we have not violated any obligations under WTO. The second submission here is we fall under the ambit of public moral policy exception. Public moral policy may be interpreted very widely. So in this case, we are referring to the case of EC seal products, which is a case before WTO, which states that in order to determine what is a public moral policy for a country, you can assess their legislative history and intent. In the legislative history in the present case is that we do have Immunity of State Act in place, wherein we are trying to take away the state immunity of a particular country who are involved in acts of terrorism or are a supporter of terrorism.
The EC Seals case was under Article 20 of the GATT, not under the security exception. Article 20 of the GATT, where basically the whole issue was about the morality of killing seals in order to make seal bags, etc. And the European Union said we are going to impose an import ban on anything related to seals that are killed in an inhumane manner. That had nothing to do with Article 21, which is the one you are invoking on security exception. A basic question is, since you're invoking the Article 21 of the WTO, which has its own dispute settlement mechanism, why should the International Court of Justice entertain an argument that is based on a WTO agreement?
Your Excellencies, firstly, my first submission was security reasons. This was under public moral policy. The EC Seals case, probably I was not clear in my submissions. Under public moral policy exceptions, I tried to use this case of EC Seal. I'm extremely sorry if I couldn't put forth it that way. Secondly, Alora and Rimasa are both parties to WTO, and there's a requirement that every state has to be treated equally. So there can always be a claim that these sanctions regime are violating the obligations under WTO. We are trying to clarify that under WTO, we are bound to not discriminate between countries while dealing with their goods and services. But we fall under the exception of security reasons and public moral policy. And that is why we wanted to...
I'm sorry to interrupt you again. You are invoking a provision from the World Trade Organization's GATT agreement, which is a security exception, for which there is an established dispute settlement mechanism under the World Trade Organization. You're inviting us to interpret Article 21 of the GATT in order to determine whether your measures satisfy the requirements of the security exception under the GATT. Do we have the jurisdiction to be able to do that when you have a self-contained regime, more or less, under the WTO? And the question essentially goes to the extent of, can you both agree to exclude the jurisdiction of the dispute settlement mechanism and outsource that dispute to a third forum like the International Court of Justice? It's essentially the question. It's a very straightforward question. Is there anything that allows you to exclude the jurisdiction of the mechanism that's created for the WTO and say that we don't want to go there, we would rather prefer an arbitration or the International Court of Justice?
Your Excellency, I would seek ignorance on that. I'm extremely sorry.
Just I'll give one clarification on this issue. Whenever this issue, whatever we are discussing currently now, is a multiple issues have been involved in this, not only for the WTO of the trade related alone. And at the same time, whenever you are bringing to the mutual consent with before the ICJ, that the initial the principal position, the ICJ will decide whether the ICJ has a jurisdiction or not. So this, you have already been passed to these things. The ICJ have already been decided to have a jurisdiction to entertain this matter. So in that context, this wherever you are bringing the multiple issues, where you are not invoking the arbitration or whatever the mechanism has already been established under the GATT agreement. So it's depending on the parties' concerns. So ICJ has not given any particular area of jurisdiction to entertain the matters. And at the same time, where we are bringing to the matters before the ICJ, that it's concern of the parties. If the other parties' concern have been taken this one and all, that ICJ can have a jurisdiction under the ICJ statute to entertain the matters.
Okay, okay. Thank you so much, Your Excellencies. Thank you. If Your Excellencies allow, can I move ahead with my next submission? The next submission here is that there's a harmonious nexus that exists between public international law and human rights. In this particular case, we are trying to use the general comment number 6 of ICCPR, which states that state parties must enact a protective legal framework, including effective criminal prohibitions on all forms of arbitrary deprivations of life. We are trying to establish that the sanctions regime, which is a proportional sanctions regime, does not exceed necessity. So our submission here is that a harmonious nexus is present between the human rights ambit, and we are not violating those rights, but we are in our own ambit trying to give a proportionate response to the injury suffered by us. Thank you, Your Excellencies. These were my submissions.
Counsel, I have a small query. Are you aware of Article 38 of the Statute of the International Court of Justice?
Yes, Your Excellency.
So what are the sources that we are required to consider while determining a dispute?
Right. So the customary international law, then general principles of law of civilian nations, civilized nations, conventions, and the opinion of the jurists that are there. So that can be a primary source of law.
So have you utilized, have you and your co-counsel, co-agent utilized all these sources in your limb of arguments?
Your Excellency, when I used the United Nations Convention, that was one. I tried to use the jurist's opinion, that is another aspect. RCWA is a customary international law, so that is another. Then the fourth, okay. Regarding general principles of civilized nations, the just cogence norms, these are general principles.
Insofar as custom is concerned, you just mentioned custom. What are the elements of customary international law that you would like to tell us?
Right. So, established state practice and opinio juris. These are the two essentials of customary international law.
What do you mean by opinio juris?
Basically, when there's a state practice that has been going on for a lot of years, it develops a sense of legal obligation on the other party, and when that legal obligation is imposed, it becomes a sense of obligation for the parties to follow it, even it may not be codified somewhere. So that is what I understand in layman terms with customary international law.
Thank you.
Thank you, Your Excellencies. It was an honor. Can I please go ahead with my prayer? I'm extremely sorry. Can I go with my
Our prayer we have read.
That's what my brother says. You need not read them again. We are satisfied. Thank
We
you.
are satisfied.
Thank you, Your Excellencies.
You may save your time for the reference.
Ladies to the bench, the agent would like to close his eyes. If the bench permits, we would like to submit our memorial. The agent would like to refer to the bench as Mr. President and Madam President, if they permit the same.
No, it's all
individually.
No, not individually. You address as a bench.
Much obliged. Your Excellencies, my name is Tanima Mandal and I am the counsel on behalf of Mate Kingdom of Ellora, and my co-agent will be dealing with issue number 3 and 4, and the agent will be dealing with issue number 1 and 2. If the bench permits, I would like to proceed with issue number 1.
Yes.
The issue number 1 has 3 core arguments and which are further divided into sub arguments. I will refer to my first core argument, that Ellora's compliance with international obligations, and it has a regulatory framework that it followed which tells us that Allura has taken all due diligence and sovereignty in financial regulation. I would like to refer to the case of Nicaragua versus United States. The citations for the same are 1986 ICJ 14 June 27. In this case, Nicaragua alleged that the United States had violated its sovereignty by supporting the by supporting the Contras in their insurgency against the Nicaraguan government. The ICJ ruled that the United States had violated its obligation under international law. However,
Sorry to interrupt. Will that judgment not go under the opinion of ICJ will not go against it? Because at the final round you are for the respondent. Responsible for the acts of a terrorist organization who is alleged to have nexus with your officers. With that judgment of Nicaragua, how do you get out of it? You are citing it in your defense. I am just asking you. Go out of those facts.
Thank you for the question.
Nicaragua said that my rights are violated, and that was upheld. Right.
Thank you, Mr. President, for the question. I would like to say that there is a very precedent principles that were set up in this case, and the facts of this case were very similar. And through the evidences that we are providing in our arguments, I would like to say how Allura is defending itself with the same. I would like to proceed with my argument, and I will show it. However, a key aspect of the ruling was the court's distinction between an obligation of conduct and an obligation of result. The ICJ clarified that a state's responsibility under international law is to make reasonable efforts, which the Allura did, to prevent harm or fulfill its obligation, not necessarily to guarantee a specific outcome. For example, while states must take measures to prevent acts of aggression or interference, they are not strictly liable if such acts occur despite their best efforts. I would like to show how Allura took their best effort. Allura has undertaken the Anti-Money Laundering Directive of 2022. Also, they have been part of various international conventions, and they're also signatory of Convention on Cybercrime. It has also been part of various international cooperation, and under its Anti-Money Laundering Directive, it has taken various steps to regulate the same. I would like to cite para 28 of the RRU compromise to show the same.
28.
Yes.
Yes.
If I may cite the same, the last two lines. The Mate Kingdom of Allura has provided no direct or indirect support to the Nezavimos Mate. On the contrary, we have taken all necessary steps to curb the flow of illicit crypto transactions to Nezavimos, regardless of their origin, to ensure the stability of the international financial system. Also, taking consideration to the fact that Allura is a developing country and it doesn't have enough economic resources.
A developing country can donate 50 billion to some third party. That is what the fact sheet says.
I would like
get out of that.
I would like to say that the evidence that the applicant side provide is that our two defense ministers were linked with the illicit crypto transfers. Here I would like to say that, here I would like to point the admissibility of the digital evidences in the ICJ. Firstly, they submitted as a proof, the defense minister submitted as a proof that there were email communications and they showed the same. So admissibility, I would like to say the ICJ takes that there should be a lack of authentication and admissibility. There should be an authentication and admissibility during taking into consideration of the digital evidence. In this case, the applicants or like the defense ministers, they could have forged the same. They could have manipulated the emails, and that is very easy. That can be very easily done. Also, it can be said that it was hearsay and speculation if we connect it to the transcript.
That is a possibility, but is it your distinct case that they have manipulated those documents?
Yes, Mr. President.
It is your distinct case. You are accusing the other side of consciously manipulating and presenting false evidence.
Yes, Mr. President, and it is also said, it is also believed that it can't be taken as the direct evidence until it is proved, and it hasn't gone under all the steps of investigation.
It's not that easy. Your officers have given the clue to the steamers and everything. It can't be manipulated.
Can you?
Same question I put to her, which was in their favor. How will come out of that sharing the nautical mileage and everything to the other side? That cannot be done. They cannot manage it. It's only your officer can give.
I will like to refer the bench to par number 16.
Yes.
If I may cite the same. The last two lines. However, since Nizamimos had proxies all over the world, it was very difficult to predict what might happen where. So when the ship situation, when the Nizamimos commander, they threatened that they will be carrying out an attack, we took all the measures that we could from our side. Then also it was a part that the ship escaped, but from our side we maintained all the due diligence measures. And also I would like to point out here that if we are involved in the Casa de Brol stadium attack as well, we also lost our citizens, and it was not only Ramasa, it was other citizens as well. And also I'd like to point the numerical data. There were 7 Lorans that were injured, that led to the death, and there were only 5 Ramasans. So we faced more loss, and also there was a huge political turmoil because of the same. So why would we like to make our country situation like that?
So what you mean to say is that there was no effective control over the attackers. That is your limb of argument, did I understand?
Mr. President, I'm trying to say that there is no direct...
your colleagues are agreeing with me, so you better agree. Your limb of argument is that your defense is you had no effective control over these bombarders.
Right, Mr. President. We have no direct nexus with them, and
No. Think again. The question is not whether you have a direct nexus. The question is whether you have effective control or not.
I would like to come. That is covered under my issue number 2, but I would like to go there first if the bench permits.
Just a question, your due diligence argument is part of your first proposition or your second proposition?
First issue.
Okay, so in that case, I'd like to take forward the comments by Honorable President about the passing of the ships from your territorial waters, right? It's from your territorial waters. Are you aware of the UK versus Albania case of the ICJ, where there was a similar situation where bombs were mines were installed in Albanian waters and British ships were blown up, and the ICJ was called upon to determine whether Albania was responsible for that or not, or whether it could be attributed with conduct. And the ICJ said that, well, we presume that Albania either knew or ought to have known that there are landmines within its territory, because responsibility for what happens over your territory or territorial waters is a sovereign responsibility. It comes with sovereignty. No country can simply say that, yeah, there are terrorists operating from my territory, but I didn't know.
I'm a poor country.
Yeah.
I can't afford, I don't have resources to control them.
Thank you for the question, Mr. President. I would like to answer the same. Firstly, we took all the diligent measures from our side to curb the same, but it was maybe some mistake, or it was maybe there was a lack where the ship escaped. But that doesn't mean that we did. And also I would like to focus on the part that the judgments or the precedents in the ICJ, even if the facts are similar, they're non-binding and it's on the court's discretion. And also in that case, that case differs from our case, because in this case there were various measures that were taken in good faith. I would like to say, and also we abided by various treaties that I would also prove with my arguments. If I may proceed, I would like to answer Mr. President's question of the effective control doctrine. Under Article 8 of the Articles on Responsibility of States for Internationally Wrongful Acts, RCWA, a state can only be held responsible.
Is it, just could you repeat the title which you just said?
RCWA.
RCWA. Is it draft articles or articles? Just look at your reference material in the case sheet. In the fact sheet that you have, just look at the reference material here and see what is given here.
You'll get the answer to my brother's query.
What is the fourth entry in the reference material? This page.
Is it the last page?
Yeah, it's the last page of your component.
It
See
says
what is
draft.
there at the entry 4.
Mr. President, at the last page we just have our questions. So, if I may.
Better give
Take this one. Take this one.
Entry 4 says that they are draft articles.
Proceed with your article. These are draft articles.
Thank you, Mr. President. RCWA says a state can only be held responsible for the actions of non-state actors, that is Nizami Marte, if it exercises effective control over their conduct. The principle was articulated in the Nicaragua versus United States case as well, where ICJ has given various thresholds of effective control that needs to be met. I will explain those thresholds and I will show how Allora hasn't abided by the same. First threshold is they have planned or direct specific operation. Here the state must have a decisive role in planning, coordinating or directing the unlawful acts of the non-state actor. Allora didn't plan, directed or operated in the same. Secondly, they must exercise command over their operations. We can see from the RRU compromise, nowhere it is explicitly stated that the same was done from Allora's side. And the third is, there should be close nexus to the wrongful act. All the evidence that was been submitted from the applicant's side, it can be frauded, it can be manipulated easily. So we can say that there was no state's influence that was related to Nazavimos Marte. If it satisfies Mr. President, I would like to go back to my first issue. Much
Yes.
obliged. There is also margin of appreciation that applies here. The doctrine of margin of appreciation allows states flexibility in addressing evolving technological challenges such as cryptocurrency regulation. Allora's framework respects these principles, reflecting its good faith efforts within the limits of its resources. I would also like to cite Article 2.1 of the UN Charter, which enshrines state sovereignty. Without incontrovertible evidence of Allora's direct involvement, the accusations infringe upon Allora's sovereign right to regulate its financial and political systems. So, my second main sub-argument under issue 1 will be Allora did not violate international law by failing to trace anonymous transfers. Firstly, according to the UNODC 2014, it acknowledged the inherent difficulties in tracing anonymous cryptocurrency transactions, a challenge faced by all the states all over the globe. Allora's inability to trace every anonymous transfer is not unique and does not constitute a breach of international law. Also, I would like to bring the notice to a very famous legal maxim, impossibilium nulla obligatio est. There is no obligation to do the impossible. And in this case, it was impossible from Allora's side to do the same. But it took certain measures. If the bench wants, I can refer the same to in the RRU compromise. Can the bench refer to para 12 and 13?
Yes.
I would like to cite the para. Much obliged.
Despite.
The last 4 lines. Many of such donations have been made by cryptocurrency firms, individual donors, and even corporations cooperating over the dark web. I would like the bench to focus on the word dark web, whose origin has been extremely difficult to trace. Some crowdfunding websites set up under false pretenses or with misleading campaigns have collected cryptocurrency donations which have been funneled to Nazavimos. Allura tried its best to trace, but due to all this lacks, they couldn't, and due to this lacks, Nazavimos Marti manipulated the situation on their benefit.
Is there any international agreement to regulate all this?
There is Convention on Cybercrime. We are signatory to this, but as I said, we have taken all due diligence measures from our side. So
Signatory or party to it?
we are party to it with Ramasa. We're signatory. We're signatory.
Good.
Yeah. Now I'd like to bring the focus on the principle of proportionality and sovereignty. The principle of proportionality in international law ensures state measures are necessary to achieve legitimate aims.
1 minute. As a law student, I'm just asking. Are you aware of these facts? Whether what is the meaning of being signatory or being party to it? Because I think in your curriculum, you may not be taught with these niceties, So go ahead with...
Thank you, Mr. President. I would like to bring the attention back to the principle of proportionality. Allura's it aims while it ensures that state measures are necessary to achieve legitimate aims while minimizing undue restrictions. Allura's balanced regulatory approach to combating financial crimes aligns with international standards, avoiding over-regulation that could stifle economic activity. The same is given in FATF recommendations, which emphasize a risk-based approach, granting states flexibility to tailor regulation based on specific risk. Also in the GATS, Article 14. I would like to come to my third main argument, that is the non-binding nature of the Memorandum of Understanding.
And one more aspect, why did you not go before their courts and defend your case?
So, pardon, Mr. President, can you repeat?
Why did you not go? Why did you not appear to engage a counsel when they taken matter to their courts at the domestic level?
Mr. President, because at that time our state was under, because of the loss of our citizens, our state was under a political turmoil, and there was various political situation that we needed to handle, and due to all those reasons which didn't appear, and my co-agent will be dealing with the same, and she will explain it further. While the resolution urges states to seek mutual assistance, it does not create an absolute or binding obligation, but rather encourages cooperation within discretionary power of states. The use of the word should in the Memorandum of Understanding indicates a non-binding nature, as it conveys a recommendation or expectation rather than a mandatory obligation. In international law, agreements are binding only if the parties demonstrate intent to be legally bound, as required under Article 26 of the Vienna Convention on the Law of Treaties. I would like to conclude my issue number 1 and would like to proceed with issue number 2. The first main argument for issue number 2 was the establishment of the absence of effective control, which I've already established before. So I'd like to go with my...
Yes.
So I'd like to move to my core issue number 2. The Allora is not responsible for militant attack at Casa de Brol Stadium. As my applicant referred to para number 22 and 26, I would like to refer to para number 16 and 21.
16 of the
Comprom, yes. As I've already stated in the last two lines that Nizam-e-Mulk had proxies all over the world, it was very difficult to predict what might happen where. So it shows that we have taken all the necessary steps from our side. And also I would like to bring the focus to para number 21. It shows that there was a tremendous public outcry over this horrific incident, which was extensively covered by global media outlets. Family members of deceased took to the streets. Now I would like to I would like the bench to come to the last 4 lines of this para. Families of 7 Allorans who had died in the Casa de Brol Stadium approached the Supreme Court of Allora for compensation. However, no relief was offered to them. I would like to say there was condolences from our side that was offered to them, and also we tried our best to do whatever we can, and we tried to show that it was not our duty because we were not involved in the attack, and we don't have any obligation towards the attack. I would like
but
to
they
prove.
were your citizens? Were they your citizens?
Yes, Mr. President.
That's all.
I would like to show that there was not an attack from our side through this subpoints. Firstly, the attack does not qualify as terrorism. Under international law, as clarified in the Lockerbie case, terrorism requires intentional targeting of civilians with the aim of instilling fear of coercion. The evidence presented does not support this categorization of the Casa de Brol attack. Secondly, there was no nexus between Allora's action and the attack. Under Article 16 of RCWA, a direct link must exist between a state support and the wrongful act. As in the Nicaragua case, general support is insufficient to establish liability. The evidence fails to demonstrate such a connection between Allora and the attack. Thirdly, the lack of state involvement or motive. This attack resulted in the deaths of both Ramasan and the Allorans. This loss of Alloran lives undermines any suggestion that the state would knowingly support or condone such actions, as it would be contrary to its own national interests and security. Fourthly, customary international law absolves Allora. Under customary international law, as outlined in RCWA, the attribution of non-state actors act to a state requires substantial involvement. The absence of such evidence further strengthens Allora's position. Customary international law requires such exceptions to be established by treaty or Security Council resolution. Ramasa's unilateral invocations of its ISA provide to abide with the same. Now I would like to come to the part where Allora is not obligated to pay reparations for the death of the 5 Ramasans. As per RCWA Article 31, reparations arise only when intentionally wrong acts attributable to a state cause injury. Allora's lack of attribution negates the obligation to compensate. Ramasa failed to prevent the attack within its territory, suggesting contributory negligence. Allora cannot be held liable, solely responsible when the host state also bears a duty to protect all individuals within its jurisdiction. Now I would like to come to the point that there was no proven violation of just cogent norms. Just cogent norms are peremptory, non-derogable norms binding all states, such as the prohibition of terrorism. Violations require deliberate, egregious state actions with clear attribution, as held in armed activities on the territory of the Congo. Citation for the same is ICJ 2005, May 26. State responsibility for just cogence violations demand incontrovertible proof of deliberate state involvement, which lacks in this case. No evidence conclusively links Allora's alleged aid to Nizam-e-Mulk Marty's attack. As the very last of my argument, I would like to conclude that Allora did not violate any international law. Allura is not responsible for the militant attack at the Casa de Brol Stadium. Also, Allura is not obligated to pay any reparations for the deaths of the 5 Remassans. Now I would like to hand over the dice to my co-agent. It was an honor appearing before you.
Yes, when you go to court of law, you have to argue of your own, not by the brief given by the somebody written it. You have to argue of your own. I thought you were reading the brief. You were not arguing the matter.
See, 1
For
minute.
future.
Only to supplement what my brother says, as far as moot courts are concerned, in future,
Otherwise,
don't
your
read out.
expression,
Don't
was
read out.
excellent, but don't read out. That's what.
Apologies, Mr. Apologies, bench.
Don't
I
read
will
out.
make sure I don't
Because
do
Your
that
expression,
creates a negativity
your
for you.
preparation, everything was excellent. But this, anyway.
Your reading out gets into the negativities, you know.
Otherwise, you express as a lawyer very good, but keep it
Huh?
in future. You argue, express
Point
yourself.
से लिख के आने का.
Right, Mr. President.
Yes.
ठीक है.
Next.
Okay, next.
Permission to refer to the benches, Your Excellencies.
Yes.
Greetings, Your Excellencies. My name is Adrija Das, and I shall be taking up issue number 3 and issue number 4 from the behalf of the respondent. Am I audible?
Yeah.
From the behalf of the respondent, Mate Kingdom of Allura. Now, the issue 3 deals with the legality of the legislative and the judicial measures which were taken by Remasa against Allura, and issue 4 deals with the legality of the sanctions, Your Excellencies. So, if Your Excellencies have no questions, the agent would like to move on with the third issue.
Yes.
The third issue would be divided into 3 sub-arguments, Your Excellency. The first sub-argument is concerning the state immunity and how state immunity violations have been taken place in this case. The second would be regarding improper use of ex parte proceedings, and the third would be the customary law does not, taking away of immunity is not applicable in customary law. So, moving on with the first sub-argument, if Your Excellencies have no question, is the state immunity violations. Firstly, state immunity is a cornerstone in international law according to United Nations Convention on Jurisdictional Immunities of States and Their Properties, to which both parties are signatories to, affirms that states are immune from any kind of domestic proceedings, and if they are to carry out a proceeding, if one state are to carry out the proceeding against the other, there should be explicit consent of the other state. In this case, no such consent was taken from the other state, so thereby such kind of proceedings would be held invalid in the first place, Your Excellencies. This leads to my second part, which is immunity from execution was disregarded. According to Article 19 of the Immunities Convention, prohibits the attachment of state-owned assets without consent. Hereby again, I would like to reiterate that there was no consent that was taken from Allura while taking away their state immunity.
Ms. Counsel, I'd like to ask you the same question I asked the other side, which is, given that this treaty has not yet come into force, why should the court consider the provisions of this particular convention? There's an answer to this. I'm just trying to see if either of your side knows the answer.
The agent does not know if the answer to this is the right answer, but the agent would like to try once. It is a secondary source of international law, and although it is not come to force, it is present and it can be referred to as a secondary source of international law. Your Excellencies, if you are satisfied with the answer.
I'm not, but please go ahead.
So sorry. Moving on.
Particularly, why is asking, if the question is put to the petitioner, you should have been ready with the matter.
Extremely sorry. I apologize.
This shows that as a mooter, you were not that much agile with the queries which the bench was putting to either of your colleagues, you know. This goes for your personal markings, you know. I think there were marks for first 5 best booters. I think that is what the program tells me, unlike other universities.
Thank you so much, Your Excellency.
The other
Thank you for your
universities have only
guidance.
first 2 medals for the
Thank you for your able guidance.
speakers, individual speakers.
Thank you so much. If Your Excellencies have no further concerns,
Go
the
ahead. Yeah.
agent would like to move on. Secondly, immunity from execution was disregarded, which leads the agent to the third part of the argument, which is, Your Excellencies, immunity applies even in cases where there is a serious application or serious thought of or evidence of misconduct. In the case of Germany versus Italy, again, extremely sorry, there is no citations which are being provided by the agent in this case. But in the case of Germany versus Italy, which occurred in 2012, it was provided that even when one state has certain kind of evidence which is not direct in nature against the other, it does not, even if there is presence of allegations, it does not give them the right to take away the immunity of the other state from immunity from judicial proceedings, Your Excellency. So hereby applying the same principle, it can be understood that even if there is presence of allegations against Alora, it can't promulgate that their immunity against judicial proceedings would be taken away. Which leads to the second sub-argument, Your Excellency, which is improper use of ex parte proceedings. To clear it up, first of all, Alora was given proper judicial notice, and as reiterated by my learned co-agent, that due to and also provided in the RRU compromise as well, in paragraph 21, due to political instability, due to the outcry, they could not come for the same and they could not present their case. But even if there were ex parte proceedings which was occurring, Your Excellency, it is important to note that these ex parte proceedings needs to be impartial in nature. It needs to promote justice, equity, and good conscience. But in this case, as we see, the evidences which has been presented by the applicant is secondary evidence. It's not primary evidence. It cannot be proved beyond reasonable doubt. There is always a case of reasonable doubt which is brought forward when the evidences are looked into. For example, if the
One
emails...
minute. Where is your rebuttal argument? Where do you rebut them? कि ऐसा कुछ पैसा हमने नहीं sanction किया. These are not mine. Your colleague never rebutted all that. All that you are telling that we don't have control. But
Yes.
they are, जिसे हम हिंदी में कहते, वो तो आपके कंट्री में पनप रहे हैं ना. हाँ.
Your Excellency, what has been tried to prove by the applicant is the functions and the workings of Nizam-e-Most Marte was carried out and was helped and supported by Alora. But in this case, it can be rebutted by the respondents that there was no effective control. Furthermore, the evidence which has been provided by the applicant in relation to determining that there was a direct control over the workings of Nizam-e-Most Marte cannot be primary evidences and cannot be proved beyond reasonable doubt, because the emails can be faked, and furthermore the transcript also cannot be proved beyond reasonable doubt. It was published by a newspaper report. It was not given out by any government.
Counsel, could you guide us as to what is the rule of evidence for us?
The rule of evidence or the admissibility of evidence, Excellency, is that it should be clear, and it should have it should basically, Your Excellency, it should be clear in nature, and also it should show the direct relationship, and it should be reliable in nature, which takes the agent further to the argument which the agent was providing, is that the reliability of the evidences is not clear here. Because the evidences was promulgated, the transcript was promulgated, Your Excellency, by the transcript was promulgated by a newspaper report. It was not given by any government. So thereby the reliability over here comes to question, Your Excellency.
Ms. Counsel, there are two elements here. One is, of course, the effective control test. But the second argument is also that you did not exercise due diligence. Who according to you, has the burden to prove whether you exercised due diligence or not?
The burden to prove that if due diligence was carried out by Alora is upon the applicant. It is not upon Remasa to upon Alora to determine that they have like carried out the actions in due diligence.
So you are suggesting to the court that the burden to prove that you did not exercise due diligence is on them,
Yes.
but you do not have any duty to prove that, or burden to prove that you actually exercise due diligence.
It is upon us as well. It is upon Alora to rebut any claims which is made by the applicant while determining the burden of proof, while determining that we have carried out any kind of terrorist activity. So it is upon the side of the respondent to rebut such claims. But the main primary burden of proof goes upon the applicant, Your Excellency.
Can they prove a negative? You're asking them to prove that you did not exercise due diligence. Would it not be easier for the court to ask you to prove that you exercised due diligence rather than asking them to prove that you did not exercise
It is
due diligence?
definitely upon the discretion of the bench to determine, ask.
No, law requires that you, that's what my brother is saying. And second thing, madam, have you taken any action against your military persons? If you are showing that it was, have you inquired anything on record?
Necessary actions have been taken against them, although the same has not been clearly provided in the factual matrix, but it is the principles of Alora that determines that actions will be taken against them. This leads, Your Excellency, if Your Excellency does not have further question, to the other arguments, which is the duty of the courts to ensure impartiality, as it was earlier argued by the agent that there was no impartiality or justice, equity and good conscience was not followed. Furthermore, proportionality and not followed. Furthermore, proportionality and sovereign equality also was not followed in this case because as it can be seen, on the basis of certain secondary evidences, such 25 million property, worth of 25 million property was frozen of Remasa, of Alora by Remasa. So this shows that there is no proportionality in this case. There is no inclusion of international law. Your Excellencies, there is no recognized exception to state immunity for terrorism related claims. Customary international law requires such exceptions to be established by treaty or by Security Council resolution. Remasa's unilateral invocation of the ISA, according to the proposition, lacks legal basis and contravenes with the sovereign equality. In fact, Your Excellency, it can be seen that resolution was deemed to be passed, but it was vetoed. So after that, unilateral sanctions were promulgated, which just further invalidates it further invalidates the judicial proceedings as well as the sanctions which would be taken on in the fourth issue as well. Your Excellency, if Your Excellencies have no further questions, the agent would like to move on for the fourth issue.
You use the word justice, equity and good conscience. Where does it come from?
Sir, Your Excellency, it is also a principle of common law. It is a principle of international customs. International customs are basically principles that are followed worldwide and universally through time immemorial, and thereby justice, equity and good conscience are followed. When there is no proper legislation on certain issues, justice, equity and good conscience are basically the principles which are followed to determine a certain case.
Is it mentioned in the statute of the ICJ?
The agent does not have clear idea if it is expressly mentioned, but the agent would still like to bring into international customs while arguing the following case. If Your Excellencies have no further questions, the agent. So the fourth issue deals with the validity of the sanctions. Your Excellency, sanctions are not an absolute right under international law. They must conform to established principles including sovereignty, non-intervention, and proportionality. In this case, Ramasa's sanctions fail to meet these requirements. The sanctions breach Allora's sovereign rights and lack legal justification and impose disproportionate measures on Allora. Now, this argument will be further dealt with in the first half, which is sanctions breach sovereignty and the UN Charter. So, according to Article 2, Subclause 1 of the UN Charter, it has been properly given that all states are equal, and taking away the sovereignty unilaterally without any due process is invalid in nature, Your Excellencies. In this case, due process was not followed. In fact, on the basis of certain allegations, itself, such kind of unilateral sanctions were promulgated on Allora, which in itself makes it invalid. Furthermore, Your Excellency, if we look at the very nature of sanctions, sanctions are preventive or sometimes can be punitive in nature, but mostly preventive in nature. In this case, if we see that sanctions are used as preventive in nature, most of the terror financing was occurring with crypto funds, Your Excellencies. But the sanctions have been promulgated not only on crypto funds, but also on gold and wind energy. Now, there can be no direct nexus on how terror activities can occur through wind energy, Your Excellencies. So, limiting these kinds of industries which have such huge importance in Allora negatively affects Allora without any kind of due reason for the same.
Ms. Counsel, are you arguing that unilateral coercive measures are illegal in international law, and if so, what is the source of this argument?
Your Excellency, it is not illegal, but it is frowned upon, and to determine the same, I would also like to give certain examples. For example, the Libya sanctions, which was promulgated from 1992 to 2003. The Iraq sanctions from 1990 to 2003, wherein it was regarded that multilateral sanctions is better than unilateral sanctions, and unilateral sanctions are normally not accepted. This also is further accepted in Article 51 of the UN Charter, wherein it is regarded that cooperative framework in such kind of sanction regimes should be followed. And even if one is following self-defense, cooperative framework needs to be followed. Yes, Your Excellency.
Whatever three words you may use, sanctions, reparations, coercive measures, would they not fall within 21 of the Article 21A and of the Get resolutions?
I'm sorry, Your Excellency, I could not get your question.
Will they not fall within the exceptions of 21B
But
as argued by them?
Your Excellency, it
How
is.
do you meet with that?
Your Excellency.
Their argument is very clear that these are, as per the international conventions, as per the norms, we have decided that these sanctions have to be applied.
Your Excellency, it is important to notice even if the sanctions are promulgated, it needs to be proportionate in nature. There is a huge disproportionateness in the application of the such sanctions. That even if sanctions are promulgated, it needs to be promulgated on the sectors which are in relation to the terror activities. Just promulgating sanctions without any due reason for the same and promulgating it on major industries such as wind energy or renewable energy industries without any due reason is disproportionate in nature. Even if exception is provided, it is needed. It needs to follow certain norms. It needs to follow certain principles.
Are you suggesting that countermeasures, because I mean there are two arguments here. One is unilateral coercive measures, but they are justifying it as countermeasures.
Yes.
Are you suggesting that countermeasures need to be always in the same sector? Is it illegal to have countermeasures in sectors other than the one that are relevant?
it is important to note that proportionateness can be determined through the same only. Because in this case, the sectors on which sanctions have been promulgated has no relation to the case. It makes it disproportionate in nature. Now, it might deter in various factual matrix, but according to this factual matrix, Your Excellency, it is important to note that it becomes disproportionate in nature, but maybe not in all cases. Your Excellency, if if the bench does not have further questions, the agent would like to move on with the arguments.
Sure.
Well, Your Excellency, as it was argued by the agent that unilateral sanctions is not applicable in such cases, and also according to the compromise as well, Your Excellency, it can be regarded that according to the compromise as well, Your Excellency, it can be regarded that there was a need of sanctions to be promulgated, and UNSC also was to promulgate such sanctions, but it was not, because it was vetoed. So such sanctions cannot be held valid in the court of law. Furthermore, sanctions as countermeasures also is very disproportionate in here, Your Excellency. It has also been determined through by the agent through the answers to your very able questions as well, which leads the agent to the final part of the argument, which is failure to act in good faith. This disproportionate nature of the countermeasures or the sanctions is extremely disproportionate in nature and does not show good faith. It's malafide in nature, and it's with the intention to deter the economy of Alora. As it can be seen through the sanctions, Alora's economy has shrank, Your Excellency, and it has shrank considerably. And moreover, as it has been reiterated by my very learned co-agent as well, that Alora throughout the case has also been a victim, and it has also been regarded in several parts that Alora has tried its level best to reduce the amount of terror financing, and even after considering the same, such disproportionate sanctions were promulgated against Alora. Now this shows that there has been a malafide intention on carrying out such kind of sanctions. So, Your Excellency, this leads to the conclusion of the arguments, and this leads to the last part, which is violation of the principle of non-intervention. When in cases of domestic importance, it is regarded according to the principle of non-intervention. In cases of domestic importance, a third party or a third state cannot intervene. In the case of Alora as well, the terror financing was occurring within the borders, and it was of Alora's discretion to carry out certain measures to reduce the same. Alora was also trying its level best, and even after that, sanctions were promulgated against Alora. This just shows that the principle of non-intervention was not followed by Ramasa. Now this leads the agent to the conclusion of the arguments. If the learned bench wants to hear the prayer.
Anything wrong is wrong. You justify in any manner. Would you still say that the Alora was justified in not controlling the things?
Your Excellency, according to the factual matrix, it was never provided that Alora did not control. Alora tried to, Alora did its level best, and in fact, according to the factual matrix, it was also seen that Nizavi Most was a very sporadic organization. It was present everywhere and anywhere. It was carrying out its function through dark web. It was extremely developed, and Alora was trying its level best to reduce the functioning of Nizavi Most Marte. So there was no omission in the case of Alora.
I thought your international law argument would have been, the primary argument should have been that it was carried out outside of your territorial jurisdiction. It was not within your state that the terrorist activity was carried out. What it was, that the allegations were that it was supported by your organization, then you could have gone on to state sovereignty and state responsibility by saying that the state itself per se was not directly involved. So your argument should have been built that it was outside of your jurisdiction, therefore there was no direct involvement, therefore also the proportionality of the sanctions comes into question, that they were disproportionate to the act that has been alleged. I think that should have been your primary argument.
Your Excellency, that is a wonderful argument, but extremely sorry for not promulgating the same.
Thank you.
Thank you so much. It was a pleasure arguing.
May I request the President, sir, is all the, you finished with your
Yes,
arguments?
yes, you are.
Can we skip the rebuttals and
I think
with a request?
we have assessed
Because
that,
you will be judged by what we have heard you loud
and
and
one thing
clear.
I tell you, you people must be congratulated because I have never been participated in this book court. My brother might have done it. And the
This
first
is my
day-
27th.
No, first day, not as a participant. First day when I appeared in the court, I was shivering. You people are confident, and here or there, don't worry about who wins, but to appear itself in a final, each one of you deserves compliment.
Thank you so much for
We
aiding guidance,
completely
sir.
echo the sentiment expressed by our president.
And as I would quote at the end what learned my river once said in one of the speeches, coming first is not always that material. And he complimented Mr. Devang Nanavati, who stood second in that competition by, I think, India, Times India. So first or second, don't bother. What my brother tells you is, take back what we have told you, don't read. You committed the same blunder, what your colleague committed. She committed mistake.
Both sides.
Yes, both sides. Don't read. Don't give a feeling to the judges that you are reading.
You have to maintain eye contact.
Eye contact, your expression. Thank you.
These two
Best of
pens
luck.
are for you. One for you
I
and
hope
one
you
for
come
your
to the
colleague there.
argument and not going to the.
Thank you for your assistance. Thank you.
Don't go to the corporate culture. Court in court, it's the everyday challenge.
So we need to give the grade. We need to give this motion.
She is collecting.
Thank you very much and all the very best to all of you.
Thank you very much. All the best to you.
I request everyone to please keep your phone on silent so that it doesn't disturb the event. Please make sure. And everyone is requested not to use the phones during the event.
Hello.
Everyone is requested to please settle down and keep your phones on silent.
Hi, I request everyone to either turn off their mobile phones or keep it on the silent mode. We'll start with the ceremony momentarily. Thank you.
Greetings everyone present here. It is with great pleasure that I, Thaja Hijam, the Moot Court convener of the Moot Court Society, along with the two of my conveners, Nishant Bogale and Sanadi Dixit, on behalf of SCLML, welcome you here in the auditorium. As we come towards the periphery of the great event, the RRU International Moot Court Competition, round 24, we have the gracious presence of our Chief Guest of Honor, Justice Surya Kant, Distinguished Guest of Honor, former Justice Kalpesh Javeri, Vice Chancellor of RRU, Professor T.P.N. Patel, Pro Vice Chancellor, Professor Dr. Kalpesh Vandra, Director of SCLML, Dr. Dimple Rawal on the dais. It is equally an honor to welcome all the dignitaries present off the dais who have graced us with their presence. Mr. Yedla Umar Shankar, Mr. Amit Mohan Govil, Mr. Mihir Yashodhan Kanade, Mr. Shikhar Ranjan, for which we are immensely grateful, along with Mr. R.K. Singh, Professor joining us from GNLU. As we plan to move ahead in the valedictory ceremony, I now invite Reed Sodhi to take the event further ahead.
It is my honor and privilege to invite Professor Dr. Bimal N. Patel to felicitate the Chief Guest of Honor, Honorable Justice Mr. Surya Kant, who has taken out his precious time to grace us with his presence. Thank you, sir. I request Sir Bimal N. Patel to felicitate our distinguished guest of honor, former Justice Mr. Kalpesh Javeri, a member of the Permanent Court of Arbitration. Thank you, sir. I request you to felicitate the esteemed presence of Mr. Yedla Umar Shankar, Director and Legal Advisor, Ministry of External Affairs. Thank you, sir. I now request, sir, to felicitate Mr. Amit Mohan Govil, Director General, Central Economic Intelligence Bureau. Thank you, sir. I humbly request you to felicitate Mr. Mihir Yashodhan Kanade, Academic Coordinator of the University for Peace and the head of its Department of International Law. I request, sir, to felicitate Mr. Shikhar Ranjan, Director of Asian African Legal Consultative Organization. Furthermore, I humbly request, sir, to felicitate former Judge Dr. Kaushal Thakur, Honorable Chairperson, Gujarat State Human Rights Commission. Sir, I request you to be seated on the dais. Thank you very much, sir, for doing the honors. As we move forward with the valedictory ceremony, let us take a look over the RRU video followed by the SCLML video.
Rashtriya Raksha University. Rashtriya Suraksha Sarvopari. A safe, secure, and developed nation requires the inculcation of the highest ideals of citizenship and citizen-centric services with intellectual acumen, more commitment, and professional competence. To inculcate these eternal values and ethos into every citizen, and to create well-trained personnel in the field of national security, the Honorable Prime Minister of India and the then Chief Minister of Gujarat, Shri Narendra Modi, envisioned a university for national security. Rashtriya Raksha University. Rashtriya Suraksha Sarvopari. Rashtriya Raksha University earlier functioned as Raksha Shakti University. The university was transformed as an institution of national importance under the Ministry of Home Affairs by the Parliament of India on the 1st of October 2020. RRU aims to provide an academic research training ecosystem for national security and policing in India and to friendly foreign countries, laying new benchmarks and standards with the help of qualified, committed and motivated academic and practitioner faculty from India and abroad. With the guidance and patronage of the Honorable Union Home Minister Shri Amit Shah, RRU is laying a strong foundation and preparing a pool of dedicated young women and men who are aspiring to serve the nation in strengthening its security and contribute to development through serving in armed forces, Central Armed Police Forces, Central Police Organizations and State Police Organizations, as well as private, corporate and industrial security organizations. Spread over 230 acres land in Lavad, Gandhinagar, generously donated by the Gujarat government, RRU has been receiving support from the successive leadership of Gujarat since 2010 and is being nurtured by the committed institutional leaders. RRU covers all aspects of national security and works for smart police. Certificate, diploma, undergraduate, postgraduate and doctorate degree programs are offered in these areas. Security and Scientific Technical Research Association, SASTRA, and the Atal Innovation Centre are India's first national security innovation centres with an objective to facilitate a quadruple way engagement between academia, innovators, industry and the government for innovation, incubation and technology acceleration in the security space with application of science, engineering and technology. An aggregator of security-oriented startups, innovators, MSMEs and others, Sastra is an active contributor to the Atmanirbhar and Atma Surakshat Bharat. Global and national experts, practitioners and faculty identify and deliberate on national security challenges and issues, impart contemporary and futuristic training and education, work towards enhancing the police image for their competence, dedication and caring services, as well as empowering women in security. The university aims to create and sustain global footprints for security education. Each school has a particular vision and mission and is equipped with the latest and futuristic technology laboratories and tools. The university functions through specialized schools. RRU, contributing to the Indian Technical and Economic Cooperation Program of the External Affairs Ministry, is reaching out to friendly and like-minded nations across the globe, emerging as a contributor to the global security knowledge resource base.
Ensuring effective national security today is a far more complex task. It requires more interdisciplinary training and education and varied experience. As India rises, these challenges will grow because the stakes for us and the stakes for the world will be much higher.
Continuous professional learning and enriching the knowledge base and skill set of emerging security needs. The online integrated platform RISE provides opportunities. Training and Executive Development Directorate contributes to Karma Yogi mission of the Capacity Building Commission through basic and advanced programs in all aspects of security. Raksha Shakti School, an innovative education platform started in Gujarat, aims to prepare young people from the age of 10 years onwards through education and skills to serve the safety and security of the people of the nation. Academic recognition of security and police personnel aims to ensure meaningful social reintegration of retiring personnel, besides offering them opportunities to serve the security ecosystem through startups and incubation. Policy-oriented research and publication of reports and papers, besides joint research projects with like-minded institutions across the globe, create a narrative for the rule-based international order. Extension and outreach activities, NCC and NSS programs make learners fully aware of societal realities. RRU campuses across the country and beyond national borders connect the regions and provide learning, training and research opportunities to security aspirants and in-service personnel round the year.
राष्ट्रीय रक्षा शक्ति यूनिवर्सिटी अपना व्याप बहुत तेजी से बढ़ाने जा रही है। अब तेजी से सभी क्षेत्रों में जाकर अपना एक-एक कैंपस कम से कम खुले क्षेत्रवार इसकी चिंता करेगी।
As a center of excellence in national security and defense management and a global leader in internal security, correctional administration and police, RRU hosts learners, thinkers, strategists, practitioners and policymakers to think, deliberate, propose and implement high-standard security education, research and training. RRU is honored to serve the nation for the Sashakt Atmanirbhar Bharat mission with renewed confidence and courage.
आज हमारा राष्ट्रीय रक्षा विश्वविद्यालय देश के विश्वविद्यालयों में एक अपनी साख, एक अपनी विश्वसनीयता बनाता जा रहा है.
Rigorous examination, round-the-year incubation, internship and placement, student welfare programs, financial administration, health and safety care, efficient and timely provisioning of procurement and support services, internal oversight, quality control and assurance, hostel administration boost the realization of the core mandate of the university. RRU offers digital as well as physical libraries, normal and adventure sports facilities, and good quality hostels. Upcoming amenities and facilities will continue to provide the most conducive environment for overall personal and professional development. Sports, cultural and social programs and festivals enrich and rejuvenate the vibrancy throughout the year. RRU at glance.
यूनिवर्सिटी देश का गहना है जो राष्ट्र की रक्षा के लिए यहाँ जो चिंतन, मनन, शिक्षा, ट्रेनिंग होगी वो राष्ट्र रक्षा के लिए आने वाले कालखंड में देश के अंदर एक नया विश्वास पैदा करेंगे.
Rashtriya Raksha University, the emerging global address for security education. Do you wish to craft a legacy in the realm of law, criminology, and national security? Come, join us at the School of Criminal Law and Military Law at the prestigious Rashtriya Raksha University, an institution of national importance under the Ministry of Home Affairs, Government of India, the one-stop destination for unleashing your brilliance. Are you committed to the cause of criminal justice and national security? In a world governed by legal order, where justice is the compass guiding our path, your journey begins at SCLML, where we shape the architects of justice, fostering a community where passion meets precision. At the SCLML, we offer UG and PG programs such as BBA LLB, Honours and LLM with specialization in criminal and security laws, and MA and MSc in criminology and crime science. The school also offers academic as well as practitioners PhD in law as well as criminology. Immerse yourself in a state-of-the-art campus designed to foster intellectual growth and collaborative learning. Our world-class faculty with extensive real-world experience is committed to shaping the legal minds of tomorrow. In an increasingly interconnected world, understanding international law is essential. Our programs offer opportunities for global study and collaboration, allowing you to explore legal issues from diverse cultural and legal frameworks. For networking opportunities, you can connect with alumni, industry professionals, and professional organizations through our extensive network. Build relationships that will support you throughout your career and open doors to exciting opportunities. So, start your journey today. Whether you aspire to advocate for justice, shape public policy, or drive corporate strategy, School of Criminal Law and Military Law provides the tools and support you need to achieve your goals. Don't just dream of a career in law and criminology. Make it a reality at School of Criminal Law and Military Law. Join us to embark on a fulfilling journey toward a rewarding legal career. RRU at glance. The school.
Faculty and students of SCLML, they had undertook a project wherein LLM students from the batch of 2021 and 2022 reviewed selected books in the domains of security law enforcement and criminal justice. The selection of books was determined through extensive consultation between the concerned students and faculty. Each of the 18 reviews has been carefully scrutinized and edited by the faculty and compiled into this book. The compilation is organized into thematic sections and includes reviews of book in the vital areas of security such as cyber law, criminology, counterterrorism, and criminal justice administration. The collection is highly enriching and informative, read and shall prove to be an excellent addition to the library of academics, legal scholars, law practitioners, and judges. Additionally, these reviews will help in Indian authors to get scholarly credit as dissemination of Indian scholarship. Now, I would like to invite Honorable Mr. Justice Surya Kant, sir, and the Vice Chancellor of Rashtriya Raksha University, Professor B.N. Patel, sir, to e-launch the book on national security and criminal justice. you so much, sir. Now, it is our esteemed privilege to have with us Honorable Justice Mr. Surya Kant, sir, as our Chief Guest of Honor, who began his illustrious career at Hisar district in Haryana in 1984, transitioning to the Punjab and Haryana High Court in Chandigarh a year later. Over the years, he has represented a wide array of clients, including universities, boards, corporations, banks, and government bodies, showcasing his legal prowess. Notably, he was appointed as the youngest Advocate General of Haryana on July 7, 2000, and became a senior advocate in March 2001. Justice Suryakant sir has delivered pivotal judgments in areas such as human rights, gender justice, education, and prison reforms, establishing himself as a respected figure in the legal community. We would be honored to have him share his perspectives with us. Please, sir.
My brother Justice Kalpesh Javeri, former Chief Justice Odisha High Court, Justice Thackeray, Chairperson Gujarat Human Rights Commission, Professor Bimal N. Patel, Vice Chancellor, Rashtriya Raksha University, Gujarat, and member UN International Law Commission and National Security Advisory Board of India, Dr. Kalpesh, Pro Vice Chancellor of the University. We have among us Mr. Yedla Umashankar, Director Legal and Treaties, Ministry of External Affairs, Mr. Amit Mohan Govil, Director General, Central Economic Intelligence Bureau, Dr. Mihir Yashodhan, Chair, International Law Department, University of Peace, United Nations, Mr. Shikhar Ranjan, Director Legal, Asian African Legal Consultative Organization, Madam Rawal, Director, School of Criminal Law and Military Law of the Rashtriya Raksha University, a very distinguished faculty, other dignitaries who have graced the occasion, officers and staff members of the Rashtriya Raksha University, and above all, my dear students, especially those who have come from different institutions to participate in this international event. A very good afternoon to all of you. I am extremely delighted to be here on this valedictory ceremony of the Rashtriya Raksha University International Moot Court Competition 2024. At the outset, I would really commend Dr. Patel and his entire team for seamlessly organizing this event under the visionary and dynamic leadership, the credit for which goes to Dr. Patel. We just had a video clipping of the university, the foundation vision behind the university, the object and aim, and the vision the university is meant for. My dear friends, a nation growing economically, politically, democratically, in rule of law, in good governance, requires not only the military in dress, but lot of military elements in civilian dresses also. Whether you are in the form of a law graduate, an expert in criminal law or in international law, whether you are a professor or a scientist or an engineer, or maybe holding any other responsible position, you become part of that civilian army which very carefully, intelligently, very diligently look after the interest of its nation, within and outside both. I feel proud to be a part of today's event and to have a direct access to this wonderful institution which has the honor of being an institution of national importance within the meaning of entry 63 of the list 1 of the Constitution, that honor which goes to not many institutes in the country. The university, as I'm told, has been established under the aegis of Home Ministry. It's a completely distinctive institution which imparts specialized and a unique kind of education to the students through different courses centered around the study of national security and police. This targeted professional experience ultimately will commend and to be celebrated, I would say, will certainly set the school apart from the fast becoming trend of dilution and homogenization of legal education across the country. In the same vein, it is heartening to note that the organization of this flagship Moot Court competition by the University's School of Criminal and Military Law is also a remarkable event in that very direction. I am encouraged to see so many eager faces for the top law school across the country and maybe across the world who are here to participate in this event. A lot of enthusiasm in all of them. Of course, the nervous jitters you must be experiencing before the results are finally announced and the prizes are distributed to the winners. But I must say that each one of you, with the very participation in this event, is the winner, because what you will gain through this experience is going to be a lifelong asset, something which will always be a support to you in building your career in whatever walks of life you would like to have. Well, I don't wish to add to your anxiety, and accordingly, I will restrict my remarks to the significance of the academic exercise you all have undertaken over the course of these past few months. Firstly, I must say it's a unique pleasure and privilege to be here with you for the inaugural edition of this Moot Court competition, which I'm sure will continue to achieve greater heights and each successive edition in the years to come. With the meticulous research and to the perfection with which the event is being organized, will definitely enhance the skills, and it will be a lifetime achievement for all the dear students who are participating in it. I am of the firm belief that Moot Court competitions foster confidence, promotes teamwork, and refine public speaking abilities, which are essential attributes for whether you want to become an aspiring advocate, whether you want to become a member of the judiciary, or when you want to become an academician. The element of confidence in speaking, the oration, the expression is extremely important when you go for civil services or any other public assignment which you gain. And these are the platforms where you gain this confidence, you learn a lot. As an activity, mooting instills a sense of competition and facilitates holistic development, intellectual engagement, and the exchange of idea among the peers. Coming to the most specific issue of today's moot, I just had a brief glance at the fictitious case presented to the participants. I was immediately struck by the compelling scenarios and complex legal issues it really encompasses. I noticed how the hypothetical case being set in the backdrop of proceeding before the International Court of Justice touches upon matters relating to international law, global security, cyber terrorism, and national security, giving students a unique opportunity to gain first-hand experience of complex areas of law in a competitive setting. This is something unique. You create a problem, a hypothetical problem, which really confronts the students with different branches, different phases of the international law or the issues which become part of the legal curriculum. But where you, in a one problem while solving one issue, that you become well conversant with different branches of law. The facts of the moot problem are German for contemporary times. The factual matrix which broadly pertains to cross-border drug smuggling, cyber financing of terrorist attacks, and the imposition of sanctions clearly has a host of real-world parallels. The unconditional rise of advanced technology and the ever-increasing innovation in crime have made our world very sensitive to the issues this competition sheds a light on. It is equally a truism that in rapidly developing countries such as India, economic and financial crimes rise very high. Thus, it is most important and it's apt that the young students who are the harbingers of the future are being trained to research in these fields of law through this kind of competition. I equally appreciate the model of this stimulation where students are expected to interpret and apply various international treaties and conventions. Students must also navigate dozens of precedents and relevant documents provided to them in the case and use their keen legal minds to sift through the relevant and of course the irrelevant, both. Many of these skills are not taught in most law schools, making participation in competition in such as the Rashtriya Raksha University Moot all the more enriching. The depth with which students are expected to delve into these issues and present their cases before the panel of judges is, I am quite sure, would be remarkable. Regardless of the outcome, my dear students, your efforts in this moot showcase your commitment to excellence and have set apart and emerging leaders in the field. Embrace the valuable insights gained, celebrate your achievements, and continue to cultivate the passion and expertise that have brought you this far. The field of law, we all must appreciate, demands not perfection, but perseverance, curiosity, and a commitment to the ideals of fairness and equity. I have no doubt that your future endeavors will be impactful, to say the least. I would like to conclude by coming back to the anxiety I alluded to you in the opening remarks. The nervous jitters you all must be naturally feeling, standing at the culmination of this important competition. But dear students, the trailing couple of days were the culmination of your months-long worth of hard work and diligence. You all have already proven your mettle by deciding to partake in such a demanding exercise, and for that I applaud you all. The definition of success, according to me, is the courage to try. That's why I said that the very fact that you participated itself is winning the game. As you go forth, I would urge you all to trust in the quality of your preparation and have faith in your teams. I extend my heartfelt best wishes to each one of you for this grueling challenge this weekend, and I offer my best wishes to all of you. May you all achieve success and fulfillment in your respective journey. But always remember that as budding lawyers and advocates, your words and actions have the power to shape society. Use them wisely and always with a view to the greater good. I will leave you with some fitting words by the prudent Al Warren, a former Chief Justice of the United States. And he said, and I quote, "It is the spirit and not the form of law that keeps justice alive." Be it in a mock stimulation here in the court before you, or in the real time, the commitment to justice and excellence is what will ultimately be your salvation. I'm quite sure, having seen the environment, the commitment, the dedication, and the goal and motto of this university where you have come to participate, each one of you will get a different kind of a confusion, a confidence, and an infusion of so many thoughts which will really help you a lot in building your career. A feeling of nationalism, the feeling of your commitment to the nation, and a sense of your responsibility toward the nation, I'm quite sure will be multiplied with your the stay, your participation, and learnings in this university campus. My best wishes to all of you. Thank you very much for giving this opportunity to me. Thank you. Jai Hind.
Thank you, sir, for your kind words. Your address was truly inspiring and enlightening for all of us. Now I would like to invite Anirudh Gupta and Vagisha Negi for the most awaited moment of the valedictory ceremony, which is prize distribution.
As we near the prize distribution ceremony, I would invite Honorable Mr. Justice Suryakant Sir and Professor Dr. Bimalan Patel to felicitate the winners Prince Sarthak, Shrikant Mishra and Harshit of the quiz conducted on the theme of national security. Thank you, sir. With a bated breath, let's come to the highly anticipated part of the valedictory ceremony. The competition, the RRU International Moot Court Competition, saw extensive participation and legal brilliance. It is with immense pleasure that we come up to announce the quarter-finalists of the RRU International Moot Court Competition 2024.
I would like to invite Sir Shikhar Ranjan to come up and felicitate the quarter-finalist. BIDS Law School, Sanvi Sen, Sakina Tashriwala and Aditi Sahani.
In absentia, we move forward. The second team, the Gujarat National Law University, Gandhinagar. Can we please have you on stage? Anushri Saxena, Jhalak Bhatia and Hetvi Dholakia.
I would now announce Kathmandu University School of Law, Sitsma Dahal, Bigya Katiwada, and Amun Karmacharya. Okay.
In absentia, we move forward. The Ram Manohar Lohia National Law University, Lucknow. Can we please have you on stage, Monarch Trivedi, Sakshi Tiwari, and Dushyant Singh? The Ram Manohar Lohia National Law University, Lucknow. Monarch Trivedi, Sakshi Tiwari, and Dushyant Singh. Thank you so much, team. Thank you, sir, for doing the honors. Moving ahead, I would like to call upon Sir Dr. Mihir Yashodhan Kanade to felicitate the semi-finalists of the first RRU International Moot Court Competition 2024. First and foremost, MGR Educational and Research Institute. Can we please have you on stage, Zubair Ahmed, Shraddha Warrior, and Anthony Samuel Geoffrey. Now I would like to call upon stage Tamil Nadu Dr. Ambedkar Law University, Chennai. Can we please have you on stage Ahmed Akhil, Kamlesh Nath, and Shruti Sundari. Advancing towards the awarding ceremony of the top 5 memorials of RIMC 2024, it is my proud privilege to invite Sir Amit Mohan Govil to felicitate the winners. I invite on stage Maharashtra National Law University, Nagpur to receive the award for the 4th ranked memorial. Can we please have you on stage, Maharashtra National Law University, Nagpur. I invite on stage Gujarat National Law University, Gandhinagar to receive the award for the 3rd ranked memorial. I invite on stage Kathmandu University School of Law to receive the award for the 2nd ranked memorial. Can we please have you on stage? Coming to the end of the top 5 memorial award, I call upon National Law Institute University, Bhopal, who have won the Best Memorial Award and a cash prize of INR 51,000. Can we please have you on stage, NLIU Bhopal? Yes, sir. Yes, sir. Vanshika, this.
Man, let them go. Now, the moment of truth. Do you guys have any guesses who are the runners-up? Advancing ahead, it's my honor to call upon former Justice Mr. Kalpesh Javeri to felicitate the runners-up of the RRU International Moot Court Competition 2024. Okay. With the bated breath, I call upon team Symbiosis Law School Pune to come up the stage and collect the runners-up trophy and the cash prize of 81,000 rupees.
Congratulations to Symbiosis Law School Pune for being the runners-up of the first RRU International Moot Court Competition. The claps should be rolling for the time and effort they have put in making this effort. Thank you so much, team. Thank you so much, sir. To award the champions of the first RRU International Moot Court Competition, it is my humble privilege and sincere honor to invite Honorable Justice Mr. Suryakant and Professor Dr. Bimalan Patel, sir, to felicitate Maharashtra National Law University, Nagpur, who have displayed legal expertise, intellectual brilliance, and persuasive advocacy, and have not only showcased in-depth knowledge of law, but also their remarkable skills in presenting compelling arguments under pressure. Can we please have MNLU Nagpur on stage?
Congratulations to the team. Moreover, it's a proud moment for announce that the winning team shall be provided with an internship opportunity under Dr. Professor Bimalan Patel, Member United Nations International Law Commission. Once again, a huge round of applause for the champions of the first RRU International Moot Court Competition. On the behalf of the organizing committee and everyone involved, we extend our heartfelt congratulations to the team.
It is also a proud privilege to inform that subscriptions worth INR 1,27,000 has been provided by our knowledge partner AIR and our knowledge partners SCC and Manupatra, with subscriptions ranging from 15,000 to 25,000. As we come to the end of the valedictory ceremony, I would like to invite Kaushal Thakkar sir to come and give his vote of thanks.
Good afternoon. My Lord Justice Suryakant, Senior Judge, Supreme Court of India, my Lord Justice Kalpesh Bhai Javeri, I won't say retired Chief Justice, is still more active than many of us, Dr. Bimal Bhai Patel, Madam Rawal, and all the dignitaries on the dais, of the dais. It was really great honor for Raksha Shakti University today to have been bestowed by the presence of two luminaries, Justice Suryakant and Justice Javeri. I stand before you because Justice Suryakant, sir, said that he would not be adjudicating, but would be observing. That is how I got the privilege of being on the bench once again with Justice Javeri after a decade. I started my career as a High Court judge a decade ago with Justice Javeri as my mentor. You all are blessed that the prize winners have got the prize from Justice Suryakant. And as I can't thank him more. Though tomorrow is a busy day, he has bestowed his presence on Gujarat, not only for 1 day or half a day, but full 2 days. So we are really thankful from the bottom of our hearts for being here with us and blessing the students. Thanks to Justice Javeri. Thanks to all the dignitaries who are here, who have come from all the way from Costa Rica, Delhi, other parts of the world. Thank you very much. And I would request Bimal Bhai to have these moot courts on the international, inviting international students now also. Thank you very much, all of you.
Thank you so much, sir, for extending your vote of thanks. I am humbly privileged to thank all the guests on the dais, off the dais, all the students, participants, and all the audience to have been here in this auditorium to witness this valedictory ceremony. With this, we come to the end of the ceremony, and I request everyone present here to proceed to the grand porch for a group photograph. Thank you.